is on the petitioner, and both of you have attorneys who will cross-examine each of the parties who testify, I'm sure. So that's basically the sum total of where we are at this point. So I wish that y'all had been able to resolve it. I thought we perhaps had a band-aid approach that might work for 2 to 4 weeks that would have achieved many of the things that your attorneys had been working towards, and both have done a fine job of thinking outside the box. So we may have gotten a little too far outside our box for this court and what its power and authority may be. Um, but there were ways to make it happen, and so you have turned it over to me, and I will be uh, handling these issues and see where we go. All right, Ms. Shockley, you're representing the petitioner. Do you wish to give an opening statement very briefly?
Yes, Your Honor. Thank you. Um, so, yes, I'm Rachel Shockley. We've just met this morning. It's nice to meet you. And I represent Dr. Courtney Stewart. I previously represented her in her divorce from Mr. Hawkins, who is the respondent in this matter. The divorce was finalized at the end of November, November 29th of 22. So they have not been divorced long. Um, Mr. Hawkins did not want the divorce, and during the period of the divorce proceedings, he harassed and abused Miss Stewart throughout the entire process, calling her personal and work phones incessantly, texting endlessly, showing up at her house when she was paying for him to live somewhere else. I spent a significant amount of time speaking to his counsel. He went through 3 different counsel. I spent a significant amount of time begging them to try to get him to stop communicating with her when it was, and to refrain from the harassment and stalking behavior. And unfortunately, it did not end during the divorce process, and it has continued after the divorce process, and it has indeed escalated rather than de escalated, which is unfortunate and not what we had hoped. The parties are the parents of one minor child, Harrison Stewart Hawkins. He is one. For that reason, they will always have a connection. Okay. And so that is, we can't just say we're not going to pay attention to each other. They will always have a connection. By agreement, Miss Stewart has sole legal and physical custody of the child, and Mr. Hawkins has certain visitation. Miss Stewart wants Mr. Hawkins to have a relationship with his son, but unfortunately, Mr. Hawkins weaponizes the child, including refusing to give his location, refusing to return him in a timely fashion. But more basically, he just uses the child as a way to contact, as a means of being in contact with my client constantly. And while he attempts to pretend that the communications are about Harrison, they always devolve into harassment and abuse. And just the sheer number of communications is harassing, abusive, and rises to the level of stalking. And then the content is just takes it to a whole nother level. The evidence will show to the point of the incessantness. The evidence will show that even post divorce, he will call Miss Stewart on her personal and work phones repeatedly on almost a daily basis, just one call after the next. There's no reason for these calls. He texts her incessantly, texting her over and over when she does not engage or when she asks him to stop. There are pages and pages of messages from him, and he won't stop, even though she's not responding. Even when there's nothing of substance to discuss, it's just spewing anger. The parties also use OFW, and he sends unnecessary and threatening messages through the app, in addition to the text messages and the phone calls. We will provide the court with examples of these text messages and OFW emails, and the court will see that Mr. Hawkins degrades Ms. Stewart. He uses profanity constantly. He makes such statements as, your medical, meaning your medical insurance, is canceled, to which Ms. Stewart responded, okay, thank you, I'll get coverage for his ASAP, to which he responded, you sure fucking will. He repeats it he repeatedly makes veiled threats by saying such things as, "You're only making this more difficult on yourself. It's all fun and games until you realize the game is over. You have no idea what I can do. I hate you. You can fuck off." He calls her names: dumbass, fool, fucking asshole. You're a horrible person. He repeatedly tells her to shut up. Um, and this is all in writing. So there's really no way that he can deny that. My client will also testify regarding things that he has said to her that are of similar nature, threatening, that he's going to, she doesn't know what he's going to do, threatening to contact the medical board and cause her to lose her medical license. And then most horrifically, and what really sort of, we finally just had to say uncle, was he threatened to kill her this January. And she will testify as to how that occurred. Um, so that goes to something very important for the court to understand. That is that Mr. Hawkins is is in law enforcement. He was a police officer. He is now currently with emergency management at GSU. He knows, because of his position in law enforcement for many, many years, he knows how to walk a very thin line as to, and he thinks that he can outsmart the system. And he tells Miss Stewart that he can outsmart the system. For example, after Miss Stewart filed for divorce, he pushed her while she was holding their infant and said, "I've been a police officer for over 20 years. I know better than to leave a mark." And so it's those kinds of things. He often becomes violent. He's damaged property. He damaged property at the house when they were married, kicking walls, slamming doors until they cracked. While all of that is scary enough, Ms. Stewart's fear of Mr. Hawkins is intensified exponentially by the fact that he has an arsenal of weapons. We have some photos of certain of these firearms, but he has even more than those that are pictured in our exhibits. As part of the divorce, he was supposed to give her an inventory of the firearms, including the serial number, etc., and he's supposed to have them in a safe for the child's protection. He has not provided the inventory, and despite being served with the TPO requiring him to relinquish his firearms to law enforcement, he has not done so. He simply does not follow the rules. He does not believe that they apply to him. And so to date, as far as I know, he has not turned over the firearms to the police, even though we appeared last week on this matter. And he has not secured, as far as we know, he has no way of securing the guns in his apartment where the child visits. He is known to leave weapons out where a toddler could access them. For example, we have a picture of a handgun in a compartment in a couch right next to the remote control. So these are legitimate concerns, and that's why they were addressed within the context of the divorce. One might wonder why Ms. Stewart didn't file for protection from Mr. Hawkins a long time ago. And she will testify that she is afraid of him, that she always just tries to keep the peace, so that things don't get too bad, that there isn't just like she would rather him just be calm. And she will testify that here today she's very concerned, and that she stays up at night wondering if this gets entered, what happens, and if it doesn't get entered, what happens, because there's going to be fallout, and she's scared of him. All that said, she wants him to have a relationship with his son, despite his constant accusations that she wants to ruin that relationship. She has done nothing but support it, even in the face of all of this abuse. And largely that's because Miss Stewart is a rule follower. And he is the father. She wants him to be involved. He has visitation schedules. She's going to follow the rules. Unfortunately, he hasn't followed any of the rules. He hasn't followed the temporary order. He didn't follow the divorce decree. He hasn't followed the divorce decree, and now he isn't following the TPO. And he just believes he's above the law. And so there's got to be some repercussions. There hasn't been any, there hasn't been any like consequences that matter to Mr. Hawkins, and he throws that very much in Miss Stewart's face. And for example, the perfect example of this is after having been served with the TPO, he continued to contact her by phone and text. we notified him, my office notified him in addition to him being served, in addition to us notifying his employer so that we could receive the handguns that are, or the firearms that are associated with his work. And he just decided that, nope, sorry, I don't believe that this is a legitimate, or I don't think this is valid. And so he just continued to do whatever he wanted. Um, and so, he acknowledged in his correspondence that there was a TPO, but he was, quote, deciding that it wasn't valid. And so he was just going to continue his behavior as he so desired. Um, as though all of this wasn't enough, upon information and belief, Mr. Hawkins has been hacking into Miss Stewart's emails and her internet system. Early in the divorce, he was ordered to sign over the internet account to Miss Stewart when he left the house. Per usual, he refused to do it, even though it was a court order. He didn't do it. She finally got a second account because she was worried that he was accessing her system. He has a background in IT. And then, interestingly enough, it wasn't until the TPO issued, but he finally canceled that first account as soon as the ex parte was in place. And so my suspicion is that he has been reading her communications for for a year or more. Um, the evidence of family violence is clear. Mr. Hawkins must be prohibited from continuing to harass and abuse and stalk Ms. Stewart. He needs help. He needs classes in domestic violence. His conduct is interfering with Ms. Stewart's ability to parent, her ability to work, her ability to get the child medical treatment. He refused to bring the child to an appointment one day and refused to say where he was. This is just destroying her life. She's constantly worried about what he is going to do next. Is he going to throw another fit at the daycare and they get kicked out of daycare because that happened? That could potentially happen considering former behavior that she will discuss. Is he going to throw a fit at the bank to the point where the bank employees asked Miss Stewart if they would like, if she would like for them to call the police? Is he going to refuse to return the child? Is he going to refuse to pick up the child? Is he going to refuse to bring the child to the doctor's appointments? Is he, it just goes on and on. And he is stalking and terrorizing Ms. Stewart. And we are asking this court to enter the 12-month protective order and all of the relief that Your Honor set forth previously. And that would also very much include the surrender of all of his firearms. And it is our understanding, and my client will testify to, I do believe that if he was a police officer still, that the obviously not being able to have a firearm would impact his employment. But from what he explained to my client when he received the new job at GSU in charge of emergency management, firearms are not required. He requested that he be allowed to maintain his badge and his firearms, and they granted that, but it is not, in her understanding, a requirement of the job. And I have seen nothing that states that it is. And so I'm assuming that it is not required, and that was something that he asked for, and he was given that privilege. We are asking that visitation be modified during this period, that no overnight visitation occur, that it be supervised for a period of time. And certainly we would suggest perhaps that be the period of time be when he was attending the family violence program, and that once that was complete, that then we could maybe move away from supervised visits and back to something more normal. The child is 17 months old. He's a 17-month old. He gets into stuff. You have to have a lot of patience with him. And this is, this is an age where you need patience, and that's something that Mr. Hawkins doesn't have, and that could result in a disaster. And indeed, he constantly returns the child early from visitation because he doesn't have the patience to parent him for any extended periods of time. And so, that's something that we're asking for in addition. I think it's important to know, Your Honor, that Mr. Stewart rented a one-bedroom apartment, despite the fact that he has a toddler and probably should have gotten him a place with his own room. But the apartment is it's just right over a mile from Miss Stewart's residence, and he can be at her house in just minutes if he gets enraged. She would not have time to get the child in a car seat and leave the residence if he decided that he wanted to come there and hurt them. And indeed, when he rented the apartment, he told her it was, quote, within striking distance. And so that has also been something that has weighed very, very heavily on her, and particularly as things have escalated to the threat of killing her. Ms. Stewart and Harrison need to be protected. I believe when the court hears from Ms. Stewart and reviews the additional evidence, the decision to grant the 12-month protective order will be clear. Thank you, Your Honor.
All right, Ms. Robinson, do you wish to give your opening?
Yes, Your Honor. Good morning. My name is Janae Robinson, as we had met earlier, and I have been retained to represent the respondent, Mr. Harry Adam Hawkins, in this matter. And we are here today before this court to assert that there's absolutely no grounds for this protective order, as the petitioner, Ms. Stewart, nor the parties, minor child Harrison, are nor ever were at any time before or during the parties' marriage in any at risk of any imminent harm, danger, or injury attributed by Mr. Hawkins' actions. As we are prepared to support with evidence, including our family wizard correspondences between the parties, as Ms. Shockley had stated, that these issues involved in this matter are not that he poses a risk up to their safety, but that they're in fact proper for contempt. These parties were recently divorced at the end of November, and there were certain things in the parenting plan, the final divorce decree, as well as the settlement agreement, in which both parties were instructed to comply with. And as you will see today, that all of these things that Ms. Stewart has taken issue with, as she has falsely stated that they are proper grounds for a TPO, actually proper for a contempt matter. And therefore, we would request that this court dismiss this protective order so that these issues can be properly resolved in the proper court. Now, Ms. Shockley just came before you to try to paint this picture of Mr. Hawkins as some type of villain, as someone who has done nothing but harm and harass the petitioner and break all the rules for the entirety of their relationship. However, what she failed to mention is that Miss Stewart is not as much of a rule follower as she claims. She too has not followed some of the parenting plan, some of the settlement agreement as the parties have proceeded past the
Okay, we're getting some freezing
and
up.
other documents of the
Ms. Robinson, hold on a second. I'm not catching everything.
actually in both
Ms.
physical
Robinson, excuse me for interrupting.
I just remembered that this happens and there's a bunch of technical issues, but so far we have a doctor mom and a cop dad divorced in late November with a 17-month-old child, and the mom wants a TPO. So I can't remember if there's a point in this video where they had to disconnect, I believe, and do something else because the respondent's lawyer's internet was so bad. But let's watch on. If it's super bad, I will try and skip forward. Oh, kitchen is getting cleaner.
Can you hear me? Okay, you're on mute now. Okay, your screen was freezing, which also distorted your vocal as well. Your audio was off.
I don't know. I think she's frozen.
Frozen again.
Can you hear me now?
Yes, you're breaking up a little bit, but try again.
Okay, how about now?
Much better. Okay. I'll ask you to repeat the last 2 or 3 sentences at least.
This Okay, there's a delay because when I speak versus when you hear me is different.
Okay, well, it was distorting it. So go ahead. Let's see how we go.
Okay. Miss Shockley just came before you and tried to paint Mr. Hawkins as some type of villain, some type of rule breaker. However, what she failed to mention is that Miss Stewart herself is not as much of a rule follower as she claims. She too has not followed the parenting plan. She too has not allowed Mr. Hawkins to have the visitation as he is ordered to in the court. There has been times in which she hasn't responded and which she has made things difficult in order for them to co-parent. She is the one who actually imposed.
Okay, you're frozen again.
Let me text her. I don't know why it would either not be always wrong or
Well, we were having the issue in the hearing I had previous to this one, but one of the parties was in Oconee County. I understood there were some storm issues in his area, so I'm not sure what's going on, but maybe she can log on again and let's see what happens.
you might need to try to call her, Your Honor.
Well, or her client can text her or call her if possible, sir.
Your Honor, yes. I've got her on the line now. She's having internet difficulty. She's trying to log out and log back in at this time. So,
Maybe we'll get a better connection then. Thank you.
I just got a text from her. She says, my paralegal says our internet is down.
Uh, I was so over the Zoom world after COVID, and I was so happy to get back in the courthouse, and then all the pipes bust, flooding many of the courtrooms.
Good service on my phone anyways, but I'm trying to get this resolved. I'm sorry, the whole internet. I'm literally using someone's hotspot right now, but the whole internet. So I do extremely apologize for this inconvenience.
All right, you may proceed while you can.
I know, I'm trying to get it out really fast, man. But yes, however, during the party's marriage, Miss Stewart was actually the one to physically impose harm against Mr. Stewart. However, even after filing this TPO, Miss Stewart continued to engage in regular communications and interactions with Mr. Hawkins. You will hear today from Mr. Hawkins through testimony, as well as proof by our family wizard messages, how even after Miss Stewart filed this temporary protective orders, she continued to talk about the minor child. She continued to even instruct Mr. Hawkins about the proper care for the child after he had his ear procedure. And in fact, she agreed to meet with Mr. Hawkins and did at a public park. Now, when she met, there was no police present. The police were never called. There was no one else to supervise this exchange. It was just Mr. Stewart, their child, and Mr. Hawkins. Nothing happened. They were at no point of time at risk of their safety. And if they are, Miss Stewart took absolutely no means to protect themselves as she claimed she needed to. And they had a peaceful exchange and went about their business. And that is because at no point of time during the party's marriage, nor at any single time during the divorce proceeding, was domestic violence an issue, an allegation, or mentioned by Ms. Stewart. The parties engaged in mediation, in which they were required to fill out the domestic violence survey, in which neither Mr. Hawkins nor Ms. Stewart stated that Mr. Hawkins had ever committed any type of violent act against her during their relationship. And that's because he was nor is a risk to Miss Stewart's safety, and especially not the party's child. This action is improper and a farce upon the court and a waste of this court's time and resources, as all these matters should be properly handled and addressed in a contempt action related to this divorce. Now, these accusations against my client and the imposition of this protective order would not only substantially impair upon my client's ability to continue to foster the loving and intimate bond that he has with his only son, but it will also have severe consequences as offenses against his character and his reputation as someone who was in law enforcement for years and someone who still acts in a law enforcement capacity. Mr. Hawkins is currently employed in an emergency management situation in a law enforcement capacity with a local university here in Georgia. He's in charge of being in charge of all the security monitors and managing all of the security protocols for the university. As a former law enforcement officer and one who is in charge of thousands of students' safety and who understands the risk of firearms and working with vulnerable populations and what severe implications would come through from threatening to kill someone's life. Now, Mr. Hawkins has never made such a threat against Ms. Stewart. Having this action against him, having this protective order granted against my client would go against the very oath he took and promise he took to protect the people. It would have a substantial impact on Mr. Hawkins' current career and any future career opportunities as a law enforcement officer, as it would substantially impose upon his ability to care for his son, as well as provide for his son with a life that both parties agree that he deserves. Now, there's no evidence of harm, as the petitioner is erroneously claiming. Mr. Hawkins at no point of time threatened to kill her, and you will see that there is no evidence, apart from Ms. Stewart's own words, that he ever threatened to kill her. Now, we have a multitude of messages as well between Mr. Hawkins and Ms. Stewart from the time in which the petitioner claims these behaviors begun to show the interactions between the parties and to further prove that Ms. Stewart's claims are erroneous, false, and misleading. Now, in regards to Ms. Stewart's claims in regards to the firearms, Mr. Hawkins, as I stated, is a former and is currently a law enforcement capacity, and he owns a firearm, one that is issued by his employer. Now, however, as a result of his career change and the birth and the age of the minor child, he no longer has use for these guns to be in his home. And as you will hear from Mr. Hawkins himself, all of the firearms in which the petitioner will claim that he has are no longer in his possession, and that they are in fact secure in a protected place outside of his home and are at no risk to the party's minor son. He will not he is willing to offer the petitioner